Good evening, Mr. Moosa.
Good evening, ACJ.
Thank you for availing yourself and thank you for attending this session.
My pleasure.
Yes, you have been nominated for consideration for appointment as a judge of the Gauteng Division of the High Court. And I see that you hold the degrees of BA Law and LLB, both from the University of Durban, Westville, now University of KwaZulu-Natal.
Yes, that is correct.
And you got your BA Law in 1987 and your LLB in 1990. Is that right?
That is correct.
And then you've got some certificates and some diplomas that you have set out in your in the questionnaire.
Yes, that is correct.
And you worked as a prosecutor for about 6 years, from 1988 to 1992, is that right?
That is correct, ACJ.
And as state advocate in the Department of Justice, 1992 to 1996.
Correct.
And then you say you have been practicing as an advocate from 1997 to up to now, is that right?
That is correct, ACJ.
Did you also lecture?
Yes, I have lectured to students in academic development as well as for lead practice management.
Yes. You are a member of the National Bar Council of South Africa.
That is correct, an NEC member of the National Bar Council of South Africa.
Yes. Did you do pupillage?
Yes, I've done 6 months of pupillage at the time in 1996, before I, in fact, started practicing.
And where did you do it?
I did it here in Johannesburg.
Yes. Okay. So you have been practicing from 1997 as an advocate up to now. That means you have been practicing for about 24 and a half years or so.
That is correct, yes.
Yes. Can you tell us what types of cases you have been handling in your practice for the past 24 and a half years?
ACJ, initially I specialized in criminal work. My practice for a very large portion was criminal work, and subsequent thereto, I then proceeded to take on civil and commercial work. And also during the course of my practice, I was involved in quasi-judicial work, which involved me chairing disciplinary tribunals, as well as during certain times working or acting on behalf of the city of Johannesburg in quasi-judicial matters, as well as for the University of Johannesburg, where it was initially known as RAU, but then it became University of Johannesburg, as a prosecutor on the Student Disciplinary Committee. So I've had a varied practice in many areas of law. Yes.
So it's criminal work and chairing disciplinary hearings. Is that what you have said in terms of what work your practice?
No. Correction. I have done civil work. I've appeared in the High Court over many years doing civil work.
Yes.
Appearing in opposed motions, running civil trials.
Yes.
Writing opinions. I've been involved in the entire sphere of the law.
Yes. And what branches of law has your practice?
Well, I've been involved in administrative law, family law, matrimonial law.
Yes.
I've been involved, I think, in a broad range of matters that would require one to deal with in practice.
And have you got any reported cases that in which you argued or which you did?
Well, the one that actually comes to mind, Honorable ACJ, is the one that I had whilst I was still a state advocate in the Durban High Court. It was State versus Safadi. It's a reported judgment, and it dealt with the access to the police docket to accused persons. And coincidentally, my opponent in that matter was the Honorable CJ that appeared against me. And that is one of the reported judgments that come to mind in the time that I was with the state.
Who was your opponent?
Sorry, mate. It was. Just bear with me for a second. It just slips my mind.
I thought you said so.
It was. Sorry.
I thought you said CJ.
Yes, it was the ex-CJ. He was a counsel in Durban. It just slips my mind at the moment. It'll come to me in a short while.
Was it the then advocate Pius Langa?
No, it was
Was
not.
it the then advocate Ngobo?
Yes, Sandile Ngobo.
Yes.
Yes, I apologize for that. Yes, it was Advocate Sandile Ngobo that appeared against me.
Yes. Okay. Is that that was before you started practicing as an advocate? You were still
Yes.
Yes.
And then whilst I've been acting from 2015, I think I've had about 4 or 5 judgments that have been set out that according to me, have been reported.
Well, before we come there, in terms of cases which you argued or in which you were involved as an advocate over the past 24 and a half years, you say none has been reported.
Not that I can remember now.
Yes. Okay, and you have acted in the High Court. You have
Yes,
acted in the High Court.
That is correct. I've acted in the High Court.
Yes. For how long have you acted in the High Court?
I've acted since 2015 to date for a total of 174 weeks.
Yes. Did you do a mixture of civil work and criminal work, motion court, criminal appeals, civil appeals?
That is correct, Honorable ACJ. My spreadsheet will indicate that I have done I've done 80 weeks in the criminal court, and the remainder of the time I've done in civil court.
Yes. So altogether it's how many weeks?
174 weeks.
174 weeks. So it's, is it more or less 50-50?
Yes, civil is slightly
Civil
more than
and-
the criminal, yes.
Oh, okay,
Yes, yes.
okay. And you say out of the judgments that you have written as an acting judge, 5 of them have been reported.
Yes.
Yes. Are they reported in the in the usual South African law reports?
I'm given to understand, yes, they are on SAFLI, reported on SAFLI, as I understand.
Yeah, not on the usual South African law reports.
Not that I'm aware of.
Yes, okay. All right. Judge President.
Thank you very much, Acting Chief Justice. Advocate Moosa, good afternoon. Good evening. Sorry.
Good evening, JP Mlambo.
Yes, I think just to close 2 gaps or so in what the Acting Chief Justice led you on. I see that you did 12 full weeks in the opposed motion court as well as 22 weeks in the civil trial courts. You confirm that? That's what your spreadsheet says.
Yes, I confirm that.
And when it comes to the urgent court, I see 12 full weeks as well.
That is correct.
Now, you also have 5 weeks in special motions, right? Those are the special allocation applications, is that correct?
That is correct, yes.
Right. But these acting periods that you've reflected here also include your acting stints in the Mpumalanga division, am I correct?
That is correct, yes, JP.
Right. What I want you to do is to allay the fears, if one may use that language, regarding your reserve judgments as well, especially those that you have listed at the end of your spreadsheet. You've listed 7 judgments that were delivered between 9 and 11 months out of a total of the 276 judgments. Yes. I think just before you talk about it, and I don't want you to tell a long story, the judgment that featured in your interview in April, has there been a recurrence or a recurrence, or whatever, I'm not English speaking, a recurrence of that type of conduct where you've reserved an urgent court judgment for very long?
Never.
Right. And in terms of the judgments you've listed here, they all seem to be judgments that featured before or in your interview, because we're now sitting in October, and I think the most shortest one is matter number 60, which is 9 months.
Yes.
So since April to now, you've not reserved anything beyond 6 months?
No. If I may just come in, Honorable JP, this list where it says from number 1 to 7,
yeah,
that list is for 2017. And from 2017, that has never ever happened again, up until the time that we speak now.
I see. Is that all you want to say to the Commission about those judgments, or is there something else you want to say about them? Because
yes.
You know that reserve judgments and long outstanding reserve judgments is a problem.
Yes.
In the Superior Courts.
Yes.
That's why I'm raising this with you to deal with.
Thank you for that, JP. You will observe from my spreadsheet that I have handed down 276 judgments in the period 2015 to 2021.
Yeah.
Of those 276 judgments, 266 of my judgments have been handed down within 3 months. Category B, which says just over 3 months, but under 6 months, I have identified and disclosed 3. And I want to specifically go to the category C, which says judgments handed down after 6 months, and there are only 7. And I respectfully submit that if one takes a look of the number of years that I've acted, which is 7 years, I've had these 7 in the period of 7 years. But if you were to take a look at from matters number 19 to 93, you would have observed that they would have been specifically only during a certain period, and that was in 2017, 2018. I have never ever had a recurrence of that specific difficulty after that specific period. And the difficulty at that stage was a personal challenge that I had had. It was a difficult stage in my life at that stage, in my personal life. And I've now obviously resolved those issues in terms of ensuring that I've got sufficient time to deal with these matters. And you would find that in most of my matters, I hand down judgment in a few days or maximum in 2 months' time. Complex opposed motions, matters in the urgent court, I hand them down very, very quickly. So I want to give the committee the assurance that on the last occasion, when I came and Honorable Malema had taken issue with the judgment in the urgent court, since that particular judgment, I've never ever had a problem in the urgent court, despite acting for 12 weeks in the urgent court. Even when I've been dealing with special motions, I've been handing down the judgments speedily. So I can give you the assurance that I have never ever had that difficulty after 2017. And it's almost like 4 years that I've never had that problem, JP.
Okay. Thank you very much. Thank you, Acting Chief Justice.
Thank you, Judge President. MEC Lesotho.
Thank you so much, Acting Chief Justice. I just want to follow up from the last appearance. that advocate came to see us. It was quite a heavy one, and I'm glad he's indicating that he has learned from that interaction. And I just want to get from him, if you said you have learned besides the court-related matters of delivering judgments and other things, at the personal level, what is it that he can bring to our attention that indicates that that last interaction has indeed managed to make him to grow or to be a better person?
Yes, thank you so much for that. I can safely say that having been here in April 2021, I was specifically conscientized to the seriousness of having a judgment reserved for a lengthy period of time and how serious this commission in fact views that type of conduct. And having been sensitized and conscientized about that, I specifically have learned from that specific exercise. And obviously, I have not ever found myself in that position again, where I've had to unnecessarily reserve judgments. I've learned my lesson, if I may say, and I have realized that it is important to be able to deal with it speedily and to hand down judgment to the parties speedily.
I was saying at a personal level, because if you don't succeed and you see the names of other people that were part of the interview that you participated at, it may affect you emotionally and otherwise. I'm just trying to establish that you've overcome those limitations.
I think on a personal level, I'd like to just share with the Commission that I have a passion for the law. I have a passion for justice, and I have a passion for the administration of justice, as well as to serve the people of the Republic of South Africa. And having made myself available for that, I have had to realize that obviously the people are above my own individual needs and my wants and my requirements. And when the time is right, and when the people have spoken and have decided that I am deserved of being appointed permanently, I shall accept it. I think over the number of years that I've acted as an acting judge, the number of years that I've been involved in corporate, interaction in the corporate world, the number of years that I've acted or worked as a commissioner and chairperson of the Ethics Committee, the Magistrates Commission, as well as sitting in the LPC, one learns and realizes that one has to put one's own feelings, thoughts above that of what you want to aspire to. So on a personal level, I accepted it in a good spirit, and therefore I believe that I am deserving in the future of becoming permanently appointed, and hence therefore I've applied again to come here, and that alone should indicate my level of commitment to the judiciary, and secondly my fortitude that I will continue trying until I'm successful.
Thank you so much, Acting CJ. Thanks, Advocate.
Thank you.
Thank you. Commissioner Dodovu.
Thank you very much, ACJ. Good afternoon, Mr. Moosa.
Good evening, Commissioner.
Yes, afternoon. Yes. I can see that today you ooze with confidence. I listened to you in 2019 when you were here.
Yes.
Even this year in April. For me, there is much difference and improvement, and that in itself is a positive development, and thank you for that.
Thank you for that.
Now, I know that you chair an important committee in the Magistrates Commission, the Ethics Committee. Can you share with this committee, this commission, how important it is, that commission, that committee, in the life of the magistrates and in ensuring that we instill discipline within that fraternity?
Thank you, Honorable Commissioner. I was appointed to the Magistrates Commission in 2013, and during my initial tenure at the Magistrates Commission, I was appointed as the chairperson of the Ethics Committee. And in the time that I have been sitting as the chairperson of the Ethics Committee in the Magistrates Commission, it necessitated both myself and my team of commissioners to obviously look at matters carefully and to apply the rules carefully and to ensure that the image of the judiciary never ever was tainted or lacked luster. So as the chairperson of the Ethics Committee, we have ensured that we've maintained or attempted to maintain high standards within the lower judiciary. And we've had a very balanced view, as I would like to think, in terms of dealing with disciplinary matters. It's not that in every single matter, one would normally have to proceed with a Regulation 26 investigation and to then subsequently discipline. If matters are of such a nature where you believe that perhaps a judicial officer can maybe benefit from the mediation process or perhaps being sensitized, I've been embarked in respect of that aspect, and we have had tremendous amounts of success thus far in the Magistrates Commission as the Ethics Committee. My job also, my duties, sorry, Commissioner, my duties also involve inter alia in traveling to the many seats of the courts, interacting with the heads of courts, trying to put oil on troubled waters, appear before the portfolio committees as well in brief parliament.
And I'm aware that you report to Parliament regularly, quarterly,
Yes.
in terms of the work
Yes.
of the Ethics Committee on behalf
Yes.
of the Magistrate Commission. Have you ever at one stage submitted report late, or not submit reports at all?
I think we in the main ensure that the reports are submitted on time. I don't recall any occasion where reports have been submitted late. I don't recall.
Okay, fine. Thank you very much.
Thank you.
Thank you, Mrs. CJ.
Thank you, Commissioner Nyambi.
Thank you, ACJ. Evening.
Good evening, Commissioner.
I must also join and commend you the manner in which you have dealt with the issue of your last interview about the reserve judgment. It's clear that you took it in a very positive spirit, and you interviewed very well even last time. But that issue was a serious issue. It was about the standing of judiciary in our country.
Yes.
Probably if we can give you an opportunity to share with those that are watching that might be in the same situation about the reserve judgment when coming to an interview here, a message to them. Because the spirit that they are displaying today, it's clear that out of that experience we have learned and we are sending a very positive message.
Yes.
I really commend you for that.
Well, thank you so much for that, Honorable Commissioner. I think as a judicial officer, the cornerstone of being a judicial officer is to subscribe to the highest standards of ethics and integrity. And I think as a judicial officer, one must not be above criticism. And where you have erred, you must be able to accept it. You must be able to accept the criticism, but don't fall over and crawl into a hole. I think you need to learn from that experience. And I appreciate what had happened on the last occasion. It had given me an occasion to sit back, to survey the landscape and learn from my mistakes. And I think the message has been made crisply clear to me that the judiciary expects judicial officers, and not only the judiciary, but the public at large, expect judicial officers to ensure that they get decisions speedily and that their disputes are resolved as quickly as possible. So it has been an extremely positive experience for me, and I echo the sentiments of Honorable Dodovo when he says, yes, I am confident, because if anything from the last occasion, the fact that after my last interview, although I was not appointed for permanent appointment, I was invited to the Mpumalanga division to act for the entire term. It was seen fit that I also assist in the Gauteng division. Again, this term, I'm called again to the Mpumalanga division again for the entire term. So it indicated to me that obviously there was a problem on my side that I needed to address and apply in order to be able to meet the standard that is required. And after soul searching and obviously dealing with it, I have developed and grown, and that is why I'm here today to say that I'm of the respectful view that I am ready and I'm here to serve.
Thank you, Advocate Moosa.
Thank you.
Thank you, ACJ.
Thank you, Commissioner Nyambi, Commissioner Wofu.
Thank you. Good evening.
Good evening.
Mr. Moosa. Yes. I want to join the chorus, but I agree with everything that has been said about your attitude. I just wanted you to share with the commissioners some of the attributes that you might be bringing, unique attributes you might be bringing to the judiciary. And I say that against the backdrop of a matter that I did in front of you a couple of years ago involving Uber drivers, and I can't even remember the facts anymore. But your approach there was not to simply approach the matter and, in the combative spirit that the parties had approached your court, but to try and impress upon them to look at the bigger picture and engage and so on. And I think that approach, whatever came out of it, might have saved lives, because this was an acrimonious relationship between meter taxis and Uber drivers.
Yes.
I think, yeah, something like that.
Yes.
Yeah.
Yes, I think the cornerstone of a successful judicial officer is, one, to prepare yourself properly in respect of the matter that you're going to deal with. And secondly, parties come before you in order to resolve disputes. So one must guard against entering the arena between the parties, sit on the periphery, and one must be able to then look at the matter. And from where you sit, you must understand and know that you have been called upon to resolve a dispute between two parties. And it is essential as a judicial officer for you to then identify what is an issue, identify what a possible resolution is, and then slowly and gently guide the parties in that particular direction. And at the end of the day, it must come across as if it was a resolution that was reached upon by both the parties. So as a judicial officer, you must actually facilitate the resolution of a matter, but not to come across as if you're being dictatorial, but more to be in the position of trying to mediate. And I found that having completed my postgraduate diploma in alternate dispute resolution, that it has assisted me to a very large extent in being able to mediate difficult disputes that appear before me in the opposed motion court, and to grant the parties an opportunity to perhaps maybe consider how I may view the matter with a possible solution. And I think that is how your matter, Honorable Commissioner, was in fact resolved successfully.
Thank you, Mr.
Thank you. Commissioner Matolo Repu.
Thank you, CJ, and I'm taking a lot today. I have to declare that I know Advocate Moosa.
Yes.
And he does exceptional work for us as a profession. He lectures candidates and he prepares curricula for lead. And at the same time, he's one of the advocates who avail themselves to be part of the legal sector committee. I just wanted to do that.
Yes.
Thank you.
Okay. Thank you. Commissioners who are on the virtual platform, anyone who has questions? No one. Oh, you do. Okay. President Meyer.
Thank you, ECJ. Just to mop up, good evening, Mr. Moosa.
Good evening.
Ms. Van Schalkwyk has lodged the complaint against you. Do you have anything to say about it?
Yes, thank you. Yes, you would observe in the feedback from the various bodies that Ms. Judith van Schalkwyk noted an objection against my appointment, my permanent appointment to judge of the High Court. She completed an email on the 9th of September 2021 attaching a document relating to the concurrent jurisdiction of the High Court and essentially raising 3 causes of complaint against my appointment. I have duly responded to the members of the Honorable Commission relating to this objection on the 30th of September 2021, essentially where I distilled the 3 causes of complaint. The first being the Ms. van Schalkwyk complained that I, as a long-standing acting judge, did not understand the principle of concurrent jurisdiction. Clearly, firstly, I'd like to say that the meeting summary is a summary that has been completed by not myself, but by someone else. But I think before us today, we have the chairperson of the Portfolio Committee, Honorable Magwanisha. We have Honorable Dodovo here and other members that were present at the time of the briefing. And essentially, the point I had made was not concurrent jurisdiction. Essentially, the point I made was that the disciplinary inquiry or the misconduct inquiry was held at the offices of the Magistrates Commission in Pretoria. The office of the minister that was involved was situated in Pretoria. The state attorney that was involved in the matter was situated in Pretoria. So therefore, for ease of convenience, I would have preferred that the matter was what had proceeded out of the Pretoria High Court and not particularly Johannesburg, so as to avoid parties traveling up and down to a different seat of court. So there was absolutely, the meeting notes clearly confirm that I had never at no point in time ever indicated concurrent jurisdiction, and that I didn't understand the concept of concurrent jurisdiction. The second cause of complaint that Ms. van Schalkwyk related is that I misled the committee in relation to the date when her remuneration was withheld. Now, Ms. van Schalkwyk was before the court from 2013. She initially, when the charges were filed against her, she proceeded to the Gauteng division, the Pretoria High Court, and challenged the regulations for judicial officers. She obviously was not successful there. She appealed that judgment, proceeded to the full bench of the Gauteng division, was again unsuccessful, proceeded to the Supreme Court of Appeal, and once again was unsuccessful at that particular forum. So at that point in time, it was decided that clearly there was no basis for what she was doing, and the view of the commission was simple, that she was simply delaying this process, and that is when the Magistrates Commission appeared before the Portfolio Committee and the Select Committee Parliament, that's myself, and we had asked for the withdrawal of the remuneration, or the suspension of the remuneration, and that was done in 2018, and from the documentary evidence, as I have presented, it clearly indicates that it was done in 2018 and not 2017. That is also confirmed, honorable members, and I didn't want to belabor my representation, but the honorable minister's report also confirms that. The third cause of complaint, she says that I misled the parliament in that I indicated there were cost orders that were still not satisfied from the Gauteng division in the first instance, from the full bench appeal, and from the Supreme Court of Appeal. And ex abundante cautela, I then asked Mr. Mayor, who appeared on behalf of me, to once again, notwithstanding the fact that we had already had the facts at hand in the first instance, to once again contact the State Office of the State Attorney, the offices of the laws, the Department's Director of Law Enforcement, and it is clear that those orders have not been satisfied. So essentially, the causes of complaint that were raised by Ms. van Schalkwyk relating to the fact that the Magistrates Commission, during the course of his briefing, had indicated that nothing barred Parliament in proceeding with her removal from office. But I want to just pause and mention the following, which I asked the commissioners to take into account, that I had balanced my submission to Parliament when I, in the main, requested Parliament that perhaps to err on the side of caution and to give Ms. van Schalkwyk the very last opportunity, perhaps, to allow the review process to continue. So under those circumstances, I respectfully submit that the objective evidence that I've produced in my submission clearly would indicate that there's no basis for the cause of complaint raised by Ms. van Schalkwyk, and accordingly, I respectfully submit that I'm a fit and a proper person to be appointed permanently to the Gauteng division. Thank you.
Thank you, President Meyer. We have come to the end of this interview. I think I did allow commissioners on the virtual platform. There was nothing. Thank you very much, Mr. Moosa, for availing yourself. You are now excused.
Thank you, ACG. Thank you, members of the commission.
Yes,
Thank you very much.
Thank you. Thank you.